Differences between a copyright, trademark, and registration. Copyrights, trademarks, and registrations are legal ways to protect original ideas from being stolen and used as the property of someone else. Although each one has a similar purpose, each is quite different in use and definition. Copyright for original works of writing, music, or art. Copyright is for original works of literature, drama, music, art, or intellectual property. Once an original piece is finished, it automatically receives copyright protection. Copyrights can be designated by attaching the symbol copyright, the full word copyright, or the abbreviation COPR. Available to published and unpublished works, a copyright gives the owner the exclusive right to reproduce the work, prepare derivative works, distribute copies, and perform/display the work publicly. Copyrights require no publication or registration with the U.S. Copyright Office, but there are advantages of doing so. To register your piece, you can file an original claim to the U.S. Copyright Office by completing an online registration or filling out the Form CO. Copyrights do not cover titles, names, phrases, or slogans, symbols, designs, ideas, procedures, methods, concepts, or discoveries. A copyright's protection generally lasts for the life of the authors plus an additional 70 years. Trademarks for words, symbols, devices, or names. Trademarks are for words, symbols, devices, or names that are used to distinguish the goods of one manufacturer or seller from that of another. Any distinctive name, symbol, or word is designated as trademarked with the symbol trademark. A trademark designation notifies others that the product's name and design are the company's property. However, this trademark does not protect the company from another company that produces a similar product or uses a similar name. If such a thing were to happen, the original company would have to prove that it produced the name or design first, but still may not have a legal defense without a registration. Registration, or registered trademark. A registered trademark is designated with the symbol registered. With a registration, a trademark is protected against another company's use of the name or image. A registered trademark is a federal and legal registration of the mark. Any future companies wishing to register its own design/name/image has to check to be sure that it is not like any registered trademarks. If the image is too similar and is still produced, the company is guilty of trademark infringement. Trademarks can be registered through the U.S. Patent and Trademark Office. First, you search the online database, Trademark Electronic Search System, or TESS, to determine that your mark is not claimed. Once you have determined that your mark is unique, fill out a trademark application and present a representation of the mark. The registration process can be lengthy, taking about 4 months to receive a response to your application. The registration lasts 10 years, but must be verified between years 5 and 6 to confirm that the trademark is still in use. What happens if you trademark a logo but not a phrase? The U.S. Patent and Trademark Office accepts applications for trademark registration in 2 formats, a standard character format and a design or stylized format. If a proposed trademark carries a design element and a phrase, the applicant cannot combine both formats into one registration. If the applicant attempts to save money by only registering the design version, he risks leaving the phrase unprotected under trademark law.